And we're live. We're recording.
Okay, Blair, go ahead and bring me in.
Absolutely. Hello, everyone. Welcome to this evening's edition of Triangle Blockchain Development. And tonight we have our very special guest, Eric L. Moore, who will be giving us some updates pertaining to SHLDQ as we stand right now on this September wonderful day. What is today, the 6th? Is that right? Yes. Yep. So without further ado, Eric, we're just going to go ahead and cut to it. You let me know what I can assist you with. I'm here, but you go ahead and you have the floor, sir.
Okay, how's everybody doing? Everybody ready? Everybody ready?
Great, thank you.
Ready.
How you doing, Eric?
Ready.
I think doing well.
Yes.
Okay, good to go. All right, so I can only see a few of you guys, so that's fine. I see we've got already 44 people and a few more people coming in, but I'm going to go ahead and get started with some of the basic information. I'm going to ask a couple quick questions. Anybody can answer. So anybody hear about the settlement, the Sears Holdings settlement in the last week or week and a half?
Yes.
Yes.
Okay, and most people saw like an article maybe by CNBC or the Wall Street Journal or something like that, correct?
Yep.
Correct.
Okay.
Yeah.
Has anybody seen anything yet about anything I've discussed on any of these calls, emails, or in my articles concerning a tax reorganization in any of the press? Anybody?
Nope. No, I haven't.
No.
Nope.
No.
Okay. Anybody seen anything about a shareholder payout in the public press?
Nope.
No.
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 Okay. Anybody seen anything about a bondholder payout in the public press?
I have not.
No.
No.
I haven't. No.
Okay. And most people heard, am I correct, that it was a payout of roughly 175 or 180 million? That's correct, right?
Yes.
Yes.
Correct.
Yes.
Right.
Yes.
Correct.
Did anybody hear that the payout was $700 or $800 million?
I hadn't heard
No.
any of that.
No.
No. Nobody's seen a headline that says payout 800 million, 750. Right? Nothing?
Nothing.
Okay. All right. I'm going to start somewhere else, but the payout is closer to 800 million. And I'm going to actually pull the documents and show you what happens when the mainstream press is not following a company and when they don't care about a company and when there is no incentive to give you all of the information. They can lie by omission. They are lying by omission. You cannot tell me that the Wall Street Journal, CNBC, and Bloomberg do not employ people who can look at a document like I can and tell you what the actual number is. Okay, so the cash amount and the headlines have said $175 million, something to that effect. It says a 4-year lawsuit has been settled. Unsecured creditors, no money for them. Anybody seen that?
Yes.
Okay, so here's the thing. I'm going to walk you through more of the proof of where the assets are, and I'm not going to use what they're talking about in the public press because the public press is not a court order. Everybody agree with that?
Yes.
Yes.
All right, the public press is not a it's not a Chapter 11 plan, correct?
Correct.
Correct.
And the public press is not a reorganization plan, and it does not have anything to do with what the judge approved. Is that correct?
Correct.
All right. Has
Correct.
anybody seen anybody on Reddit or Seeking Alpha citing any documents showing that you're going to get a payout or that you own assets to transform, giving you the actual documents? Anybody?
No.
Other than you, nobody.
Okay, got it. Okay, so part of this journey that we've been on, some of you for a year, some of you for 2, 3, 4, 5 years, is that the public press and the financial press has no incentive whatsoever to give you all the information or to take the small amount of time that it takes to uncover what's really going on. Because the financial press is backed by the major corporations on the stock market. That's why you see commercials from Apple, and then you'll see them talking about Apple stock on CNBC, on Bloomberg. So the regular press, as well as YouTube, Reddit, Seeking Alpha, Investor Hub, it's all the same. So if you are not a major company on the stock exchange, if there's anything to be discovered, They are not any of the major advertisers. And I'm giving you this information as a preface to why I'm going to easily show you some stuff that's not complicated legal language, but they don't have any incentive to disclose this information to you. Okay? So we are owners of Sears Holdings stock and Sears Holdings bonds. And once you have the Sears experience, I don't want you to go the opposite way. And next time you see something negative about a company, you just buy the stock without doing the research. Okay? So it's important that you actually know the difference between negative information, what I call lying by omission, and whether or not the actual information is correct. Because if some of you have been in my value investing class, you've seen the press reports from 97, the covers of the magazines from 98 and 99, and the 3 of the 4 biggest companies in world history were penny stocks in 97 and 98. And one of the largest companies in 97 to 2001 was a company called Enron. And this company was being promoted. And I show you the covers of the magazines with the CEO and the CFO. And I show you the Amazon.bomb article, which you can look up. I show you the cover of Wired magazine, where they have an apple circled in barbed wire, and the cover of the magazine says pray. And inside the article, they said stockholders should pray. The BlackBerry will beat the iPhone and you'll lose all your money. And we know how that worked out. So I'm going to walk you through 100% undeniable proof that Sears Holdings is worth at least $100 a share. So I'm going to give you no complicated legal language, and anything that is a legal word, I'm going to have Blair pull up the definition, and you're going to see how simple it is. And the best use of your time, if you're worried, is not to go to Reddit, Seeking Alpha, or Investor Hub. Is to just look up a few of the documents I'm going to send you and tell me if it makes common sense. You don't have to be a legal scholar. You don't have to be an accountant. Just tell me if it makes legal sense for some of this stuff to exist, and tell me why people who write for the Wall Street Journal, CNBC, Bloomberg, just tell me why they couldn't have spent 15 minutes going over this same research. All right, so I'm going to pull up document 2507 first. And this particular document, and I want everybody to take good notes, because I realize that some people take great notes and some people don't take notes at all. Document 2507 is the court order that approved the asset purchase agreement. So this is very important. So we're going back to February 2019. It's document 2507, and this document approved the asset purchase agreement between Transform and Sears Holdings. And if you remember from the last call, I discussed the unencumbered assets, and I went through all of the transcripts and showed you that the judge was having a conversation with the Sears attorneys, and he was asking them, is there more money, more value in the unencumbered assets than $3.9 billion? And remember, those $3.9 billion in assets that were unencumbered. Everybody here understands what unencumbered means, correct?
Yes.
Okay, everybody understands that an unencumbered asset means no liens, no mortgages, no debt whatsoever. So these unencumbered assets, as of February 2019, when this transcript was produced, it was a hearing. So we are inside of a bankruptcy discussing assets that have no creditors. We're discussing businesses that have no debt, because Sears Holdings is not just Sears and Kmart retail stores. Does everybody here on the call know that?
Yes.
Okay, so
Yes.
Sears, thank you. So Sears Holdings is a holding company that owns Sears Retail, Kmart Retail, 1,100 pieces of unencumbered real estate, about another 500 pieces of encumbered real estate, Kenmore, Die Hard, Craftsman by Sears, Service Live, Innovel Solutions, Sears Reinsurance, Sears Home Services, 10,000 acres of unencumbered land and mall parking lot space. Sears India, Sears Israel, Sears Puerto Rico, Sears in Guatemala. All right. So I named all of those businesses off the top of my head looking at you guys' screen. Okay. So Blair is going to pull up document 2507, page 5. And this is the court order that approved the transfer of our assets to Transform. And I'm going to read you who owns those assets from the court order. Everybody remember this document. You can look it up yourself. It wasn't photoshopped, and it's right in the court record from February 2019. It's document 2507, page 5. So I'm going to pull up my personal copy and read it so I don't have to blow the screen up. And I'm going to go to number, where is it? Let me find it. Hold on, everybody. All right. So Blair, you have the document up, correct? All right. We're talking about document 2507.
Correct. I got it right here.
Okay. Page 5. This document
Yes.
approved the transfer of 425 retail stores and all the businesses I just named. All of these businesses left Sears Holdings and went over to an entity called Transform Holdco. And I'm going to read you what document 2507 number 5 says as soon as I find it. I just had it. And before I pull that up, I know we have a lot of real estate people on this call, as well as some people that are into crypto. This is the equivalent of a quick claim deed. And I know the real estate people know what a quick claim deed is. So I want you to think about, from a real estate perspective, that a group of us own a property. And we're going to quick claim deed that property to the same group of people, except we're going to incorporate the entity that we do the quick claim deed to. Okay? So 10 of us own this property. Say it's worth $5 million and the rental income is $1 million. We're going to start another entity, the same group of 10 of us. The person who owns the majority of that entity, let's say he owns half of it, we're going to let him manage that real estate, liquidate some of it, because we only own the other half and he owns the rest. So he brings us the quick claim deed, and the quick claim deed gives us the exact same interest in that real estate in the new corporation as it did in the prior corporation. And because he's the largest investor and he knows this real estate and this company better than us, and he was already managing this real estate, he gives us a quick claim deed and we all sign it. Now, we become owners of that same real estate, even with the mortgages, because the mortgages are assumed in a quick claim deed if you have a mortgage on a property. Am I correct? Any of my real estate people? Any of my real estate people? If you quick claim deed a property and it has a mortgage, the mortgage does not go away, does it?
No.
No. Correct. It does not.
Okay. So if we quick claim deed a property with no mortgage on it, what happens if the same people own it? Have they lost anything if we all own the new company that it was quick claimed into? Anybody?
You haven't lost anything.
Okay. So if we gave this guy 3 to 4 years to redevelop the real estate, keep all the rent money, and do improvements and buy other properties, have we lost anything if we still have our deed?
No.
No.
No,
If,
actually
all right,
gain.
absolutely. Now, if he takes 2, 3, 4, or 5 years to pay us our interest and start giving us the rent, have we lost anything?
No.
All right.
You gain.
No.
You gain.
All right, we've gained. So as long as we're on the new entity that he quit claimed the property over to, we would have the same ownership. Am I correct?
Yeah.
Okay.
Correct.
Okay.
Yes.
Now, keep this in mind because this is going to be our ongoing theme. Anything you can do with real estate, you can do with a company or with stock. It's just usually easier to do. So Eddie Lampert, formed a new company called Transform Holdco. He went to the bankruptcy court and said, Your Honor, I'm keeping the same people in the same percentage that own Sears Holdings. But what we've got to do is we got to sell off 2 out of 10 of these companies because they're not doing too well. So we're going to take Sears and Kmart and sell off everything in the stores. But Your Honor, I need your permission to take this property out of bankruptcy. And I promise you, and I'll put it in writing, that I will not take any more of a percentage than I previously owned. And the judge said, no problem. How much time do you need to liquidate Sears and Kmart and maybe even some of the other businesses? Because I can't let you take other people's property because you only own 50%. I will not let you take this property for an indefinite amount of time, and I will not let you wipe them out. Number one, they have the same ownership just like you. So stay with me so far. So this is the court order that transferred our property to Transform. So the judge made sure in the court order the actual owner of the property was laid out. Sears Holdings is the debtor. The property owned by the debtor is owned by us and Eddie Lampert. So blow that up for me, Blair, so everybody can see it. And I'm going to read it off. I'm going to read you who owns the property at Transform. Can you blow it up for me, Blair? The highlight, it says title to the acquired assets. Is that what it says? That's page 5. Right there. Can everybody read that?
Yes.
Yeah.
Okay, so I'm going to read it off. Now, this is the court order approving the transfer of the property owned by the debtors. That's Sears Holdings. And it says, under F, document 2507, page 5, title to the acquired assets. It says the acquired assets that are owned by the debtors. Let me say that again. The acquired assets that are owned by the debtors constitute property of the debtors' estates, and good title is vested in the debtors' estates within the meaning of section 54(1)(a) of the Bankruptcy Code. Except as provided in the asset purchase agreement, the debtors are the sole and rightful owners of such acquired assets that are owned by the debtors. How many more times does he have to say owned by the debtors? Let me say it again. The acquired assets that are owned by the debtors constitute property of the estate, and good title is vested in the debtors' estates within the meaning of section 54(1)(a) of the Bankruptcy Code, except as provided in the asset purchase agreement. The debtors are the sole and rightful owners of such acquired assets that are owned by the debtors, with all right, title, and interest to transfer and convey. Does that sound like real estate terms to everybody here? Transfer and convey
Yes.
the acquired assets to the buyer, and no other person has any ownership, right, title, or interest therein. Everybody here tell me if that isn't clear, who owns that property?
We do.
Powerful.
Crystal.
We do.
Okay. Now, if nobody else has any rights to this property, okay, and this property is owned by the debtors, but it's simply being transferred and conveyed to another company. So it's owned by us. So regardless of who's managing the property, how long the property has been, quote, managed and being liquidated, this is clear. In a sale of a piece of real estate, can anybody imagine that the person selling it would continue to say that the former owner still owns it? Does that make common sense? Somebody talk to me.
Yes. Yes.
Okay, so why would you continue to say the person you're buying it from still owns it if it's not owned by that person in another form? So this is one paragraph, right? one paragraph, and they say 4 times that the debtors own these assets. Okay, I'm going to pull you down to G a little bit further. So Blair, pull up. Now, I don't know if you guys remember this, but there's something called continuity of interest, COI, continuity of interest. You can write this down. There is a requirement in a tax reorganization that continuity of interest be met. Continuity of interest means you can't quit claim deed a property over unless all of the owners transfer over. If not, there are different tax consequences. Because if Eddie Lampert were to take all of these properties and not pay us, he has a taxable gain because we haven't been paid, and we would have a taxable loss because our property has essentially been stolen or taken away. Does that make common sense?
Yes, it
Yeah.
does.
Okay, so the IRS requires that there's something called a business purpose for the transaction. You cannot do these transactions just because you can save money on taxes. So there was a case called, I'm going to pull the case up, Gregory versus Helvering. So it's Gregory versus Helvering. I'm going to spell it Helvering. It was a tax case from around 1928. And somebody did exactly what Eddie Lampert is doing, but they did it to avoid paying taxes on some property they had purchased. The case goes to the Supreme Court. It's Gregory versus Helvering. When the case got to the Supreme Court, they said, you have no business purpose to do this other than to avoid taxes. Nothing wrong with avoiding taxes, but you can't do it if you don't have a business purpose to liquidate this part of your business and pull the rest over here with the same owners. So without a sound business purpose, the transaction fails. Okay? So this court order is assuring us that continuity of interest has been met because the judge has given us a ruling that we have a sound business purpose to separate the retail brick and mortar division from the other 8 successful debt-free businesses. So all of the people online saying that continuity of interest hasn't been met, they're wasting their time. It's in a court order. Document 2507, dated February 8, 2019, page 5. There are no intelligent discussions happening online. Nobody is going over what is legally required for this transaction to pass. Without a sound business purpose, we lose the $6 billion in NOLs and tax credits. Everybody see here that this court order was approved and the judge found that there was a sound business purpose. Matter of fact, I'm going to pull that case up just for the purposes of the video, Blair. I'm going to pull that case up so people can screenshot it, and you can look up the case. It's about 2 pages. When you read the case, you're going to say, oh, I get it. They were trying to do exactly what Eddie Lampert is doing, but they were really just trying to avoid taxes. I'm going to pull the case up really quickly. Hold on one second. Let me share my screen. Let me pull it up. Hold on. My screen's not on. Hold on. Okay. Hold on, Blair. All right. Let me pull it up. That way everybody can screenshot this, and this case can be found on Google. And I implore everyone, I guess that's the word, to look up some of these cases. Let me see if it's here. Hold on. Where is it? Where is it? I had it right in front of me. Hold on. I want you to look some of this stuff up, and better yet, Blair, if you Google Gregory versus Helvering, you might find it before I do, because I had it screenshotted, and I can't remember where I put it. Hold on. Hold on. You guys can see my screen?
Yes.
Okay. All right, so hold on.
Yes.
Comes right up on Google, Eric.
If you read that case, you will totally get it. And Blair, if somebody can put that in the chat, Gregory versus Helvering. So we need a sound business purpose. Everybody can hear me, or am I on mute?
We can hear you.
Good.
Okay.
Hear you.
So the stuff that, okay, thank you. The stuff that they're debating about, the stuff that's happening online that they're still talking about was literally approved in February of 2019. So I hope you guys can understand my frustration when I get emails about stuff that has literally been already resolved. So Blair, what's our next document? Because I'm going to walk everybody through. So everybody here is clear. I want to make sure if you have any questions, I'm going to take questions. Is it clear to everybody that that paragraph says the property being transferred belongs to the debtors or the debtor's estate? Is that clear? Anybody got any questions?
Clear.
It's clear.
Okay. All right. So I want to make sure that anybody who thinks there's some ambiguity in that or something, let me know. But it looks pretty clear to me because there's no reason to sell $5.2 billion worth of assets, not counting the unencumbered. That doesn't make any sense. These lawyers have billed $400 million. I don't think they billed $400 million and they use the word owned by the debtors so many times under the paragraph that says title to the acquired assets. I just don't think lawyers making that much money for this long would make that mistake because they can't get paid if somebody gets a hold of these assets. Everybody agree with me or not?
Agree.
Agree.
Okay, so in a tax reorganization, and I want everybody to Google this. If you Google 368A reorganization, it's going to say the transfer of the assets and liabilities of one corporation to another corporation. Sounds sort of like the quitclaim deed, right?
Correct.
Now I'm going to show you that it's just somebody taking money out of their right pocket, putting it in the left pocket. So Blair, let's go to document 1730. Let's go to that screenshot real quick. All right, Blair's going to pull up the screenshot. It's document 1730. This is the asset purchase agreement, and they're going to tell you who the documents, who the assets are being transferred to. You already know who owns the assets. Now we're going to go over who they're being transferred to. All right.
Page 52E.
Page 52, document 1730. Yes.
That's it. Okay.
There's another argument, misinformation being talked about online. They say that ESL, who is Eddie Lampert, the majority shareholder, they say ESL is not the parent company of Sears Holdings. That's what they've been saying. So I'm gonna let you read this for yourself, and you tell me if the court order is wrong, or if these people talking crazy are wrong. Because a whole lot of you are really following Reddit and Seeking Alpha, and you're believing that they're giving you proper information. But at least if you're going to be online, have the guts to challenge them and ask them to show you a document. Ask them to show you something that disproves the 19 facts versus fiction document. Don't just sit there and get nervous and think you lost your money. Don't do that. Have the guts to say, why don't you show me? Can you send me a court document? And I don't mean something slandering Eric, defaming Eric. I don't want to talk about Eric personally. My money has nothing to do with whether or not Eric is a serial killer or whether he's a saint. I need you to show me where he is giving us improper or misinformation, because everything he shows me, I've seen in a court document. The biggest hurdle for most of us is we don't believe that we own the assets that are at Transform. And it's literally right there in a court order. The Wall Street Journal has access to this. CNBC, Bloomberg. So if we own the assets at Transform, Why are they only talking about the $180 million that's coming in and acting as if there's nothing else to pay us out? That makes sense. Are you ready, Blair, with the document?
Yes.
Okay, go ahead, Blair. I'm waiting on you.
Yes, I got it right there. Yes.
Oh, okay. I don't see the
Can you see
document
that?
up. No. Anybody see it?
Not I.
No.
No, I don't see
No.
it.
No.
Hold on one second.
I could see it. Okay, I can't see
hold
it.
on. Okay, hold on. Should be up now.
Yep. Okay, blow that up for me, Blair.
There we go. Got it.
Yeah, it's coming up.
Okay, thank you, Blair.
It's a little bit too big when I do that, but here we go.
Okay, everybody can pull this document themselves. It says it's document 1730, page 52 under tax result. Remember, guys, you cannot do this type of transaction simply because you want to save taxes. Okay, so this particular part of the contract, document 1730, is the asset purchase agreement. And they are telling the court who the assets are being transferred to and who controls them. And let me see if I don't have that cut out. It says under tax result that the buyer is the parent or a member of the group. Everybody see that? The buyer is the parent.
Yes.
And I'm going to explain the significance of that really quickly. A parent and a subsidiary. A parent controls a subsidiary. There are two ways to have control. You can control the board, or you can own more than 50% of the stock. If you can do either one of those, you are deemed a parent of a company. If you are deemed a parent of a company and you merge a parent with a subsidiary, the debt between the parent and the subsidiary, everybody listen to me, eliminate. Okay, am I right? Everybody heard me?
Yes.
Okay, I want everybody to write down section 332. So if a parent owes money to a subsidiary, right here, ESL is the parent of Sears Holdings. ESL owes $2.6 billion to Sears Holdings. I'm sorry, vice versa. Sears Holdings owns $2.6 billion to ESL. Sears Holdings owes $2.6 billion to ESL because they are the parent. They loaned us the money. Everybody knows this, right? We don't have a lot of bank debt. Everybody knows this from the previous call, correct?
Correct.
Okay, now ESL is merging with Sears Holdings. The problem is we're liquidating Sears Holdings. So the actual entity that we're merging with is transformed, but it has the same owners. Everybody here knows that our interest just moved over to transform. Is everybody clear on that?
Clear.
Yes.
Yeah.
Okay, so there's something called intercompany transactions. That's when a company, a parent owns stock in a subsidiary, or when a parent company has debt with its subsidiary. So an intercompany, we got some accountants on here. Is Sandra Reed on, or Tanisha, my lady, on here?
I'm here.
Okay,
Tanisha's here.
okay, Tanisha, is that called an intercompany? She's a CPA. Everybody, Tanisha's on. Do intercompany transactions eliminate?
Correct. Yes.
Okay, so would that mean that the $2.6 billion owed that ESL loaned to Sears Holdings, does that debt eliminate if they merge?
Correct. Any intercompany transactions, debt, receivables, equity, all eliminates during consolidation for financial reporting because it's not considered arm's length transaction. So that's GAAP accounting. Intercompany transactions eliminate at consolidation.
Okay, so let me explain this again. So Eddie Lampert has about 55 million shares of Sears Holdings. Does his stock eliminate when we merge?
No.
Okay, hold on. ESL
Yes.
is the parent company of Sears Holdings. ESL owns 55 million shares of the 110. So Tanisha, what happens to Eddie Lampert's 55 million shares in a merger?
It comes back to the organization. It eliminates. It's equity. Any intercompany transactions, whether it be debt or equity, receivables, that all eliminates.
Okay, so instead of 110 million shares, after the merger, we have about 55 million shares. Is that correct?
Correct.
Okay, so everybody understand that we're going from 110 million shares to 55 million shares just because of the merger. Is everybody clear on that?
Yes.
Yes.
Okay, so if we were splitting, and I'm going to round the numbers, let's say we're going from 100 million to 50 million. If we were splitting 10 billion in assets with 100 million shares, we're now splitting 10 billion in assets with 50 million shares. That would double everybody's recovery. Is that clear to everybody?
That's clear.
Yes.
Okay,
Yeah.
now, so the 2.6 billion that Eddie Lampert owed to Sears Holdings, he sold that inventory. So does everybody realize that that cash will be split among us? It wouldn't just go to him. Everybody clear on that?
A lot
Yes.
to choose from.
Okay, because if you married a woman you owed $1 million to, once you get married, can you owe each other legally? If you can't, you're one entity legally. Am I correct? Can you owe your wife $1 million legally if you're one entity? You cannot. So that's what happened with that. So ESL has merged with Transform. Document 1730, page 32, explains how we get paid. Document 1730, page 32. All right, you can pull that screen down, Blair. Now, I'm going to walk you through what was recently filed with the court. Everybody here knows I've got the court transcript, but I'm going to walk you through where we are with the assets right now. So we've got about $2.5 billion in cash because Eddie Lampert's debt was secured by inventory and real estate. This is a fact. Anybody can look this up in the 19 facts. So his actual inventory in cash was sold. So we are sitting on $2.5 billion in cash roughly just from that. Everybody clear? That's $2.5 billion, correct?
Right.
Yes.
Okay. We had a company called Innovel Solutions that was at Transform. Everybody says that has nothing to do with us. Does everybody remember we sold that for $1 billion to Costco?
Yes.
Okay.
Yes.
And we sold Die Hard for $200 million, correct?
Yeah.
Okay. Now, nobody mentioned this in the press, did they? They said we're getting $175 million. That's all they said. So I'm going to go share my screen, and I'm going to pull some of these documents, and I'm going to explain to you where we are today, and I'm going to show you how small that $175 million is compared to what else we're getting. All right, so let me share my screen really quickly. Let me know when you guys can see my screen.
Now.
Okay, all right, so I'm going to pull the documents up, and I'm going to show you what I just said. Okay, let's go. This is Die Hard. Everybody can Google this. I'm going to make sure it's documented. Advanced Auto Parts bought Die Hard for $200 million. Everybody see that?
Yeah.
All right, so let's add 200 million to $2.5 billion. Everybody, somebody keep track of this. Somebody keep track of this. So we got 2.5 plus 200 million. Everybody, somebody keep track. That gets us to 2.7, correct? Okay.
Correct.
Now we're gonna pull this. This is all publicly available. Costco just bought a logistics company from Sears owner for $1 billion. Let's look at the date. That was March 18, 2020. Does it matter that Transform sold this asset that we own? Do we lose our interest in this asset because Transform sold it? Somebody answer that for me.
It's a negative.
No.
No.
Okay, we still own this. It's just being managed by our largest shareholder. So far, we've got, somebody mute out. Somebody mute out. So we've got 1 billion plus 200 million plus 2.5 billion. That's about 3.7 billion in cash, correct?
Correct.
Okay, we've got tax credits and NOLs worth 2.2 billion. If you Google John Willings Sears tax credits. He's the premier expert on tax credits and NOLs. He says they're worth $2.2 billion. I believe him. You can Google John Willings, Sears, NOLs, and tax credits. By the way, there's been an argument online for more than a year. They say Sears has got the NOLs and tax credits. Does it matter where the NOLs and tax credits are if we own both entities? Does it matter?
No.
Okay. So if Sears Holdings is liquidating, per what the judge said, in 30 to 60 days, how can a company that's liquidated have any assets? Does anybody know how that's possible? I mean, dissolving. I'm sorry. Once the company dissolves, can it hold assets?
No.
Thank you. So our assets are going to be put into something called a liquidating trust. Blair, pull the documents up. I'm going to prove all of this stuff up. Pull up 1.3, transfer of the liquidating trust assets. And I'm going to show everybody where the assets are, then I'm going to take some questions. Now remember, I've already proven that the debtor owns these assets. Now I'm going to show you how we're going to get paid out. I'm going to prove to you where the documents are. This document was filed with the court about 6 days ago. But I'm going to give you, no, I'm sorry, Blair. Pull out the document 5370-1. Pull that one out first. Page 60 and 61. I'm coming out of my screen. It's document 5370-1, page 60. It says October 15, 2019. Okay, that's the second document. So I'm going to read. That's okay. We can do it in that order. Keep that up, Blair. Keep that up. Okay. Can everybody see that? Can you see it clearer?
Yes.
Yes.
Okay.
Yes.
Okay. This is what I want you can pull it from here first. Go to document 5370-1, page 60 and 61. I'm going to say that again. This is not Photoshop. Blair didn't create this document. I didn't create this document. Rod didn't create this document. It's document 5370-1, page 60 and 61. Again, document 5370-1, dated, this is important, dated October 15, 2019, page 60 and 61. Now, this, what you have on the screen, was filed 3 or 4 days ago. I do not have the document number in front of me, but it is the liquidating trust document. Okay? So what I just told you was in October was the liquidating trust document filed October 2019. This is a revision of that document, but they say virtually the exact same thing. Let me read you what it says. I'm going to read you. Everybody here know what a liquidating trust is?
Actually, no, it's my first time hearing it.
Okay, all right, so let me explain that really quickly. A liquidating trust is essentially like a probate estate for a deceased person. Everybody here know what a probate estate is for a deceased person, correct?
Yes.
Yes.
Okay.
Yes.
All right. So companies die just like people, okay? So when a company dies, they take the assets and liabilities of that company, they pay off the debt, and they pay the people who are receiving those assets, and they're called beneficiaries. So when a person dies and you're in the will, you're called a beneficiary. Everybody's clear on that, right?
Yes.
Yes.
All right. So we are the beneficiaries of Sears Holdings because we're the shareholders and the bondholders. So the trust document is the will, and all the assets go into this trust. Everybody here has heard about, rich people, the Getty family, the Gates, they have a trust, and their kids are trust fund babies. Everybody knows about that, right?
Correct.
Okay, so companies can do the same thing. So Sears Holdings has taken all its assets and liabilities. They sold off all the stores. They sold off Innovel Solutions. They sold off Die Hard. They sold off $5-6 billion worth of inventory. They sold $1 billion worth of real estate. They paid all the debt so far, and they put everything into this liquidating trust, and we are the beneficiaries to this wealthy company. The company is not poor. The company is wealthy. The mainstream media has focused on the 2 divisions out of the 10 divisions. You have not heard anybody discuss Sears Home Services, Innovel Solutions, Kenmore, Service Live, the real estate, nothing. You've only heard them discuss Sears and Kmart retail stores. Am I correct?
Correct.
Correct. Yep.
Correct.
Exactly.
And
Correct.
everybody says over and over that the asset purchase agreement has nothing to do with us because all of those assets went to Eddie Lampert and transformed. Am I correct?
Correct.
They say that the asset purchase agreement wiped us out. Eddie Lampert took all those assets, and we're sitting around hoping that some settlement from the lawsuit is going to pay us. Is that the general theme that people have been saying?
Yes.
True.
Yes, it is.
Okay.
Yes.
This screenshot is from a document that was filed with the court less than a week ago. Now, I'm going to read you what it says, and you tell me why they're talking about the asset purchase agreement 4 years later if it has nothing to do with us. Let me read it. It says, transfer of liquidating trust assets. And I'm going to start right near the green. Right before you get to the green. Hold on, let me find it. Where we at? I'm going to have to read the whole thing. Hold on. On the effective date, and in accordance with Section 1123 and 1141 of the Bankruptcy Code, and pursuant to the terms of the plan and confirmation order, all title and interest in all of the liquidating trust assets, which constitutes all assets of the debtors that have not been distributed on or prior to the effective date, including without limitation. Everybody stay with me, this is important. All remaining general assets, that's 1. All causes of actions, that's 2. And funds received pursuant to the settlement order, that's 3. Everybody with me so far? There's 3 places that the money's coming from so far. Everybody with me so far?
Yes.
All right, I'm going to read it one more time because I want to make sure people don't miss this. This is not legal nuance. All remaining general assets, that's 1. All causes of actions, that's 2. And funds received pursuant to the settlement order, that's 3. The settlement order was how much money? $175 million, correct? Correct? The settlement was 100. Everybody read about the settlement a couple of weeks ago. Am I correct? Am I losing everybody?
No, we read it.
Oh, we're with you.
Okay.
Yeah.
So the
right.
general assets are not money coming from the settlement order. Am I right or wrong, Rob?
You're right.
The causes of actions are not money coming from the settlement order. Am I correct?
Correct.
Okay. So let me read you where all of the money is coming from in green, as well as the rights and powers of each debtor in such liquidating trust assets, including without limitation, all the debtor's rights under the asset purchase agreement. Let me say it again. All of the debtor's rights under the asset purchase agreement. If the asset purchase agreement has nothing to do with us, why would we have rights to something owned only by Eddie Lampert? Does that make any sense to anybody here?
Nope, not at all.
All right.
It doesn't.
Okay, am I losing everybody? Let me say it again. The asset purchase agreement, people online say that agreement gave all the assets to Eddie Lampert himself. This document was filed a week ago. So why do we have rights in something that Eddie Lampert owns by himself? Doesn't make any sense, does it?
No.
No,
Doesn't, no, not at all.
Okay,
No.
Now is that consistent with what I just read you in Doc 2507? It says that we own those assets. And the asset purchase agreement court order says the debtor owns those assets. So stay with me. The trust, the liquidating trust, is the entity that our remaining assets goes into, and then they go to us. You can look this up in document 1730, page 32. In document 1730, page 32, under distribution requirement. Let me say that again, because I don't have the document to pull up. Document 1730, page 32, under distribution requirement. They explain that once the company has liquidated all of the assets, this is the asset purchase agreement, we're going to take all of the cash, we're going to take all of the businesses, and we're going to distribute it to the beneficiaries because the probate estate is over. Now we're going to pay the beneficiaries. How many people here have seen a probate estate get closed in one day? Anybody here ever been a beneficiary, ever been involved at a deceased? They don't close in one day, do they?
No, they don't.
No.
Sometimes they go for a couple of years or 2 or 3 years. Am I correct?
Correct.
Yes.
Okay.
Correct.
So
Correct.
Sears, so the fact that Sears Holdings, I want you to think about a multi-billion-dollar estate owned by a wealthy uncle. That's what Sears Holdings is, guys. So for people saying, well, if you weren't wiped out, you would have been paid 6 months ago. If you weren't wiped out, you'd be paid 3 months ago. No, this is a multi-billion-dollar estate. And our rich uncle is named Sears Holdings. And we have businesses that are still running. We have businesses we shut down and sold at a profit. We have 1,000 stores we sold. So we are just beneficiaries of this wealthy uncle who gave us an interest in the trust. So this particular trust will be set up in 30 to 60 days. Now, Blair, pull up page 62 for me from the transcript. So I'm going to show people.
Is this right here? This is document 1730, page
Oh, that's
32.
it. Yeah, blow that up, Blair. That's perfect. Blow that up, Blair. I didn't know you had it. Blow it up. I forgot I just sent it to you. So I'm going to read you guys number 4. I've sent this document about 9 times to a large group of you, and I hope it resonates now. If we have nothing to do with the assets at Transform Holdco, guys, why does the court order says there's a requirement for a distribution? If Eddie Lampert is the only owner, what are you going to distribute to himself? Does that make common sense to anybody here on the call?
No.
Okay, so stay with me. The distribution requirement is for the other people because Eddie Lampert already has control of Transform. He's running the company on our behalf, and he's running his interests. So I want you to look this up. I'm going to read you the green part first. Blair, pull the green up. Pull the first green up. This is what it says in the court order that transferred the assets. I'm sorry, this is the agreement transferring the assets from Sears Holdings to Transform. It says, number 1, shall distribute the securities consideration, that's stock, received by it to persons qualifying as holders of securities of such seller for purposes of Section 354 of the Code. I want everybody to write down 354, Section 354. I'm going to show you what that is. Number 2, shall distribute all the cash received pursuant to Section 3.1A. That section gives us $1.4 billion. You can look this up yourself in document 1730. You'll see that it was $1.4 billion, as well as all of its other property pursuant to the bankruptcy plan. Hold on. Why is he distributing all the cash and all the property if he's the only person that owns it? Does that make common sense to anybody here?
No, it does not.
No.
Oh, okay. All right, so stay with me. This is not complicated language, legal language. Am I correct? Tell me if you think it's complicated legal language.
It's not.
It's not.
Okay. Shall distribute all the cash received pursuant to Section 3.1A. And if you look up Section 3.1A in document 1730, it'll say 1.408 billion. Now, it says, and all of its other property. This is the document that transferred Kenmore, Die Hard, Craftsman by Sears, the real estate, the stores, the online business. So we're getting all of this as part of a distribution requirement. Now, what other requirements? Let's go down to the highlight, Blair. Let me read that. It says the company shall dissolve no later than the end of the 3rd taxable year, ending after the closing date. Everybody with me so far? It said the third taxable year. We filed bankruptcy in 2018, and the taxable year for Sears is 2019. 2019, 2020, 2021. But our fiscal year doesn't end until February 2nd. So the end of the third taxable year is actually December of this year. Okay, but stay with me. Look at number 4. It's not highlighted. Tell me if this does not explain what just happened. During the period between the closing date and its dissolution, shall limit its activities to those of which are merely for the purpose of liquidating its assets, which may include maintaining a going concern operation for the preservation of value, pending distribution or sale. That's what transform is, guys. Winding up its affairs, resolving and paying its debts, and distributing any remaining assets. Here's the kicker, which may include a distribution to a non-corporate liquidating vehicle. The liquidating trust is a non-corporate liquidating vehicle. If there's nothing left to pay to us, guys, is it common sense to file a document with the court a week ago creating a liquidating trust? Somebody answer me.
No.
Okay, so why are we setting up a trust if they only have 175 million going to 3 or 4 people or 3 or 4 creditors? Why don't they just pay them the money and close the case? Does that make any sense to anybody?
No.
Yes.
Okay, so they're setting up a trust because they've got to get these businesses and cash to all of us, not just the 3 people they talk about who are getting part of the 175. This is in the document. So document 1730, page 32, talks about the distribution requirement. Okay? Now, Professor Thompson also discussed this distribution requirement. So Blair, pull up page 62 of the transcript, and I'm going to read off what the judge was discussing about this process. So far, we've got these 4 sources bringing us money. We've got all of Transform and its cash. We've got the general assets. We got all causes of actions and the funds received pursuant to the settlement order. That's 175 million. So we got the 175 million plus everything at Transform, which is roughly 5 billion in cash and all the remaining businesses. Now, we've got roughly 1.7 billion in pension debt or liability if they make us pay it, and bonds. So we've got at least 10 billion in businesses and cash and only 1.7 billion to pay out. Does that sound like a company in trouble to you? No.
It does
If
not.
you've got 5 billion in cash and you owe 1.7, does that sound like we don't have enough money for unsecured creditors?
Oh, it does not.
Okay, so the analysis that it takes, there are close to 11,000 documents in this case, but if you don't realize that the transfer of our property in cash happened 3 years ago, everything else you're doing the last 3.5 years, you're talking about the liquidating portion. Everybody, including Wyco Researcher, Elephant Analytics, these people have no clue. They deny that a tax reorganization is taking place in the first place. They don't think it makes sense that a company was set up to move our assets over to. But if you talk to a person who knows nothing about real estate and you explain a quitclaim deed, you wouldn't waste your time with them if they said no such thing exists, because you know there's a such thing as a quitclaim deed because you're in real estate. So you wouldn't waste your time having a discussion with those people. So I'm going to give you another document that talks about who we are. And Blair doesn't have this document. It's document 1436, page 22 to 23. It's document 1436, page 22 to 23. Tanisha, your camera's on. Not sure if you know that. So document 1436, page 22 to 23. All right? So it says, without the need for any other further order of the court, the debtors and their estates shall be deemed express third-party beneficiaries. Let me say that again. Further, that the debtors in their estates shall be deemed express third-party beneficiaries of, and this particular document is covering the unencumbered assets. So they're literally using the language. So we are third-party beneficiaries to everything at Transform. Now, if you expect the mainstream press to spend time looking into a company that everybody on Wall Street thinks is broke, you are sadly mistaken. They don't do it. They don't hire attorneys. They don't hire research journalists. So you're not going to hear anything about what Sears is worth until the press release comes out explaining otherwise. So if you listen to the last call that we did, I said, don't worry about the settlement. It's no big deal. But if you pull up the settlement, you'll see a section called 507B appeal. A 507B claim has priority over the IRS. Let me say this again. A 507B claim in a bankruptcy is so powerful, it has priority over the IRS. Do you know how powerful it is to be in front of the IRS when it comes to payment? Is that a powerful claim or not? Somebody talk to me.
Strong.
Very.
Okay,
Wow. Wow.
I'm
That's
gonna
a
make
good one, E. I didn't know that one.
Okay, I'm
Oh, the
getting
way
ready to
it's
make
worded, Eric. The way
Yep.
it's worded, it's incredible.
Yeah, so look, let me make it stronger, and I'm gonna show you an opportunity you still have. A 507B claim gets paid before the attorneys on the case. And if the attorneys don't make sure the 507B claims get paid, they don't get paid. Do you think those claims get paid in every bankruptcy case, yes or no?
Oh, yeah.
Absolutely.
Okay,
Yes.
so here's the deal. You're working the case as an attorney. The IRS cannot get in front of the claim. The lawyers working the case can't even trick you out of the claim. That's a powerful claim, isn't it?
Very.
Totally.
Okay, so I'm going to tell you what happened. Eddie Lampert, and you can pull the settlement up on Prime Clerk. If you look under 507B appeal, Eddie Lampert had a claim, a 507B claim of roughly $600 million. He took his claim and he gave that claim to the bondholders underneath him. Okay? The bondholders underneath him include these bondholders. The Sears Roebuck bonds, dated 2027 and 2028. The October 15, 2018 bonds, and the October 15, 2049. So let me make it clear. The bonds that you can buy on E-Trade have priority over the IRS right now, as of the settlement. The bonds that I bought and Zalika bought for 2 cents on the dollar today get paid before the IRS and the attorneys. And they're 2 cents on the dollar. Because the money for Eddie Lampert's 507B, he gave that claim back to us. So he's not getting his $600-700 million. That money goes to us. If you look it up, it's under 507B appeal. And he just said, hey, you guys can have that claim. We all know that claim is getting paid in full because the money comes from Transform. If people had any idea that bonds selling for 2 cents on the dollar are actually worth 100 cents. So the bonds are $20 and they're worth $1,000 plus interest. Some of them were selling for 3 cents and some of them were selling for 4 cents. So those of you who do not have access to overseas accounts, Germany, Canada, etc., you can simply buy the bonds until the payout. You're going to get 25 to 50 times your money because nobody will figure this stuff out. It's too much work. If they haven't figured it out in 4 years, I promise you they're not going to figure it out 30 to 60 days before payout. So Blair, do you have page 62 of the transcript? Then I'm going to take questions.
I don't think I do, E.
Okay, hold on. Let me,
yeah, not in front of me, no.
okay, let me see if I have it real quick.
Is that
All
the
right.
one that starts with the 1.3? No, right?
No, that's not it. So let me
Oh,
finish that
okay.
one really quickly. So everybody here is clear that they're going to cancel the Sears holding stock because we're dissolving the company, but our assets are being put into this trust. We're going to get new stock, new cash, and we're going to continue as a going concern business. So this is how we get paid. If you look, Blair will send you a copy of the transcript or the screenshot a little later. The judge said that within 30 to 60 days, he wants everything. He wants the effective date to have taken place. So that means all of Transform, the cash, the assets will be in the trust. They're going to close the bankruptcy and pay us out. They said the effective date is 30 to 60 days. This is in the court transcript. It is not something I'm talking about. So once this money and this property and cash is in the trust, we are the beneficiaries because we own the property. I have literally spoken to people with 5, 10, 20, 30, 50 million invested before they met me. They do not believe what I'm saying. They said it would be on Reddit. Somebody in the comment section would have figured this out. So you have to make sure that you rely on the actual court documents, not what people are talking about online. Because the people online, some of them are paid to mislead you. I heard there's some people calling and texting, emailing, instant messaging people telling them to sell their stock. That's it right there, Blair. Blow that up. This is the court transcript from August 31st, 2021. Let me read you this, and I'm going to go back to what we talked about, and I might bring Tanisha in for a second. Let me read this. Blair, is that page 62? Blair, can you hear me? Is that page 62?
That's where it says, so, Your Honor.
Yes. Okay, so let me read this.
Yes.
Everybody, this is August 31st, the court hearing that just happened. It's page 62 of the transcript. You can screenshot this. This is not Photoshop. This is not a document Blair created. Or I keep saying that because people online say that these documents are not real. So let me read you what he said. He says, so, Your Honor, 3 years ago in October of 2019, we got to consensual resolution on the plan of reorganization. We set the groundwork for getting to monetizing effectively the insider actions, and we have now done that, which I think is only 30 to 60 days away. Does everybody here remember? Everybody see that? Okay. Now, why is he telling him that the plan of reorganization was worked out in October 2019 when the confirmation plan, I'm sorry, if you look up document 5370-1, it's dated October 15, 2019. So they are explaining to the judge that we have worked out the reorganization plan way back then. And the insider transactions are transactions between ESL and Sears Holdings that my lady Tanisha was explaining to you guys eliminate. This is legal term for Your Honor. All that money and the debt that everybody thinks we have, we got it worked out, and that cash will be in the trust in 30 to 60 days. If you go to document 5370-1, you go to page 54 and page 55. This is what it says. Pre and post intercompany claims shall be disregarded and not participate in the distribution for the liquidating trust. So exactly what we're explaining to you, because how do you distribute something when you owe yourself? So all of the money that Eddie Lampert loaned Sears Holdings stays in the company. All of the stock that he owned goes back into the company. So the company is consolidating. So the company is cut in half. The actual shares of the company are cut in half, but the assets have increased. We had no debt as of March 2020. We had no debt as of March 2020. So that's why it's important to know what's happening with Transform. Let me pull this up on my screen so everybody knows Okay, matter of fact, just go to Transform Code, look up the March 2020 press release, and Eddie Lampert announced that we had no debt except a small amount of real estate debt, and it was 175 million. So, if this is a private company, why does Eddie Lampert need to be telling us how much debt is owed on a company that has nothing to do with us? He wouldn't, because it's our company and we are the other stakeholders. So, the mainstream media will not catch on to this. Thank God, I hope they don't, because we can keep buying bonds and getting 25 to 50 times your money, because the money to pay the bonds has literally been transferred already. $175 million plus the 507B claims. That claim is in the settlement under 507B appeal. And this is what it says. I'm going to read it. The ESL defendants shall, as soon as reasonably practicable after the final approval date, either withdraw their claims that have been asserted, or at the debtor's election, assign any right to recovery on their disputed super priority administrative expense claims that are subject to 507B to the estates. So let me show you how much his claim is. Let me share my screen for a second. Remember, a 507B claim has super priority. It's in front of the IRS. It's in front of the lawyers. So let me tell you why that claim is so powerful. People who have a 507B claim have funded the bankruptcy. A person with a 507B claim, their collateral has been sold, and the cash from that collateral has been used to run the bankruptcy. So if your money is running the bankruptcy, how can you be behind any creditor? Because if there's nobody there to run the bankruptcy and no money to run it, nobody might get paid. That makes sense now, correct?
Yes.
Okay. So
Totally.
the October 2018 bonds, I think it's 6.625, whatever, they are 507B claims. Now, because this claim is about 600 million, let me pull up the screenshots. That means all of that money rolls down to the other bondholders. Let me find it. Hold on. Let me try this one more time with the share screen. Let me know when you can see my screen. Everybody can write this down. You can pull these documents up. You can see it?
Now.
Okay, I've been having trouble with pulling these docs. Let's pull it up. Everybody sees the Costco. Okay, I'm going to show, let me see where we are. Okay, here we go, right. Look, I need to read this first. I'm sorry. Let me read this first. This is important. Can everybody see what I'm pulling up? Okay, I'm sorry. That's the wrong one. Wrong document. Wrong document. Hold on. I thought I had it. Wrong document. Okay, here we go. Right here. Okay. Let's look at the ESL 507B claim. Anybody see it? Let me see. Right here. It's called an adequate protection claim. Same thing. Liens and claims. 503.6. I want you to see this other claim. See 87.8. Those are the October 15, 2018 bonds. Anything that has adequate protection is a 507B claim. Now, Eddie Lampert's 503, this was an estimate. Everybody see that 503? Take that 503 and pull it all the way down, and you get all the way to the other bondholders, okay? Because all this here is the secured debt. All this stuff was paid off in February. All this was inventory we sold. All this stuff is gone. It's paid off. Let me show you the other debt. This stuff is already paid off. By the way, let me go back just a second. This is chapter 16. I'm going all over the place, but stay with me. Remember the distribution requirement. Can everybody see this? Everybody can see that.
Yes.
This is chapter
Yes.
16 of Professor Thompson's book, Mergers, Acquisitions, and Tender Offers. I did not write this. This is in a law book, and this is on Sears Holdings, and I'm going to read it. This is the professor. As discussed previously, a target in a G reorganization that is Sears, must satisfy a distribution requirement pursuant to which it distributes the consideration received in the G reorganization. This requirement is defined in the definition section of the agreement and is implemented through Schedule 9.2 of the APA, both of which are included in the Appendix 16C. So the professor is saying the same thing I'm saying, and he's reading from document 1730. So the G reorganization requirement is that we have to get the property that was transferred because we're the owners. We're still the same owners. Okay, let me pull this other claim up really quickly. I'm all over the place. Y'all have to work with me. Okay, I already pulled it. Okay, here's the debt. All right, if you see the green debt, the claim that Eddie Lampert gave up was everything in blue with ESL on it. Everybody see ESL? Light blue?
Yeah.
Everybody see
Yep.
ESL? He has
Yep.
99.
Yes.
So that
Yes.
317 million is in cash. He gave it up. That comes to us. See the next one, 570 point, right there. He owns 89%. Gave it up. That's cash. So that's 887.1. That's coming back in cash. Go here to the 2L notes. See where it says ESL and Cyrus. Okay? 175 million. 12% of that's Eddie Lampert. See where it says 6.625% 2L notes, 89 million? You can buy those bonds right now. All that money at the top where you see the light blue has poured all the way down. Everybody understand? That 887 goes all the way down. So take 887 and deduct 89 million. Okay? Those bonds are worth par. So let me go to the next bonds. Look at the next bonds, guys. Remember, we got 887 million. If we deduct 89 million from 887, we get roughly 800 million. But we only have how much bonds left? Not the pit toggle, because you guys don't own that. That's Eddie Lampert. See? He's given all that back. So the 411 million, deduct that from 800, all those bonds are worth par. So any bond with 8% on it, the cash is already there to pay it. Any bond that says SRAC or Sears Robot Acceptance, the money is already there. It's already approved by the court. All of those bonds are par. All of them. Because that money just comes right down in that particular order. So the settlement itself makes the bonds worth par right now. Is that clear to everybody that he gave back his claim? That he's not collecting that money. That cash just rolls down the hill. And if you go to the next level of debt, it's real estate. So the real estate's already been sold. All of this stuff has already been handled. All of this stuff here. It's already transferred or already paid off. These are secured debt. Look, 88 properties. That's real estate. Those are mortgages. 138 mortgages. So that's already been handled. So that's the only debt we have, guys. This is the whole chart, except for the pension. That's it. So the bonds, after the settlement, and Eddie Lampert giving the lower level bonds his 507B. So you have the same priority. So those bonds technically are not unsecured bonds. They are super priority administrative expense claims because that claim goes all the way down this list. And you can pull all this stuff is in my last articles on Sears. These are not my documents. Have you heard anybody discuss it? Has anybody been discussing the debt? Nobody's been discussing how much debt. So here's how we're going to look at the end. The acquiring parent. Did I make the case that the parent company is ESL? The acquiring subsidiary is Transform. All we're doing is moving Sears Holdings, which is the target. We're moving over to Transform. And then at the end, we end up on top. The acquiring parent is ESL, and the acquiring subsidiary holds the assets of Sears and ESL. And all of this merges together. Doesn't show any wipeout. We're just going to move over assets and liabilities. And we have no more liabilities, so everybody is whole. All right, do we have any questions? Hold on, what is this here? Any questions? Oh, I already covered that.
talk about one more time about the chart, please?
Say it again.
Chart. Can you go back over the chart you just had up?
Okay, well, okay, the debt chart. Okay, hold on. Let me pull it back up.
Thank you.
Okay, can you see my screen? Hold on. Okay, what? Hold on. Okay, what you need me to show the debt again, or show you the bonds?
The flow chart.
Oh, the flow chart. Okay, let me pull that up. Hold on.
I'd like to see the bonds.
Okay, got you. All right, so we'll do the chart first. Okay, this is the chart, and you can screenshot this if you want. This is not my chart. This is out of Professor Thompson's book explaining how 368A tax-free organizations work. As you can see, it's the assets go, the OTC. Remember, we're the target shareholders, okay? All we're doing is moving the assets from the target corp to the acquiring subsidiary, Transform. Because remember, I read you from the court order that the parent is ESL. So Eddie Lampert is acquiring parent, and we are the subsidiary with him. When the dust settles, we just split the same assets that we owned before and liabilities. The difference is we have paid off our liabilities at Transform. So the only thing left to pay are the bondholders and the pension, and we have plenty of money right here to pay it. $10 billion in assets and cash, less than $1.7 billion in debt, and $1 billion a year in income and revenue, all documented. All right, can you screenshot that? Is that clear?
Yeah, I think that's
Okay, all right, so let me go through the bonds real quick. I'm sorry, go ahead.
No, I'm just saying thank you.
Okay, so let me pull the bonds real quick. All right, somebody wanted to go through the bond chart. All right, you can screenshot that. Or you want me to go through the actual bonds?
No, I just wanted to see it because you said you can only get that on E-Trade, right?
Yeah, you can only buy the bonds on E-Trade. Any bond that says Sears Roebuck or Sears Holdings. And it was selling for 2 and 3 cents on the dollar today because people do not know this information. When you see the bond selling for 40, 50, 75 cents on the dollar, somebody's figured it out. When you see the stock selling for $4, $5, $8, somebody's figured it out. The stock goes from 20 cents to 50 cents to nobody's figured it out. When it gets into dollars, somebody's figured it out. When the bonds get into 50, 60, 70 cents, somebody's figured it out. But after 4 years, I don't think anybody's putting the work in. I think they're believing what's on Reddit and what's on Seeking Alpha. Go ahead. So
That's
these
good.
are the bonds here too. Here go the other bonds. They'll say Sears Roebuck or Sears Holdings. All of these bonds, the settlement makes them par plus interest. They did not say the dollar amount. You saw I had to find the dollar amount. They only said 175 million. That's the cash. The actual claim that Eddie Lampert is handing over, it's cash. It's cash because it was secured. If you can see, the claim Eddie Lampert had was secured by credit card receivables, pharmacy assets, inventory, and cash. See? It's already been sold. We've closed all those stores at a profit. So that money is sitting in cash right now. Right now. Because he couldn't hand over a claim that had no value. All that stuff was sold 2.5, 3 years ago. And here's the real estate. Cascade is Bill Gates. Everybody see that? Cascade is Bill Gates. He's on the real estate. He had 108 million on the real estate. Look it up. Cascade is Bill Gates. Why is Bill Gates dealing with a guy who destroyed a retailer and is broke and doesn't know what he's doing? Does that make sense to anybody here?
No.
Eddie
No.
Lampert is also managing some of the money of the Bill Gates Foundation. It's the largest foundation in the United States. Why is Eddie Lampert allowed to do business with Bill Gates and manage billions of dollars at a foundation if he does not know what he's doing? Does that make common sense? Anybody can look this up. Eddie Lampert is managing some of the money for the Bill Gates Foundation. I don't think that would make sense if he was a crook. Do you think he could con a guy as smart as Bill Gates? I don't think so. Somebody talk to me. Does that make common sense to anybody here?
No.
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 Eddie, the stock was $150. It's 20 cents today, and Eddie Lampert hadn't sold a share because he can't sell his stock without filing with the court. Why would a person hold on to a stock down 99% if it was worth zero? Does that make common sense for a billionaire, a guy this smart, not to sell his stock and walk away from all this mess if there's no money left? Make common sense that he would still hold the stock?
Makes no
Okay.
sense.
Not at
No
all.
sense.
Not at all.
Okay, I'm just checking. Now, do you want to listen to the people online, or you want to follow the lead of the people who are making the money on Wall Street? I'm going to follow their lead. And I believe this or not, I'm going to take your question in 2 seconds. But let me say this real quick. If you believe that an anonymous person online or somebody contacting you, I don't care if they're related to me, if they tell you to sell your stock and you're crazy enough to listen to a person after getting this kind of information and facts, and if you don't have the patience, you're going to be, and you better sell, because you're going to be in horrible trouble later in life if you let an anonymous person online make your investment decisions. So Blair, you go ahead and handle the question and answer. I don't know whose hand was up first.
Let's go with Raminta.
Hello. Hi, how you guys doing? I wanted to see that bond information again, just because on the screen it was small, and I'm interested in going out there and making some purchases, but I couldn't get, I guess, a good framework of the, where I can get a good screen capture or get the information to see what to go buy.
Okay, it's easy.
How I go search it or whatever.
Okay, it's on E-Trade. Any bond that says Sears Roebuck or Sears Holdings. Any bond that says Sears Holdings or Sears Roebuck.
Okay.
Any bond. Yeah, that's how you do it. You put it in the bond search and put Sears Holdings or Sears Roebuck, and it'll come, the screen will come up. And today there were 2-3 cents on the dollar.
Wow. Okay. Thank you.
You're
Appreciate
welcome. You're welcome. All righty. Any more questions?
Any more questions, anyone? Go ahead, Adrian.
Hi guys, this is all very exciting. I just love hearing it over and over and over and over again. So I'm super excited about this, super thankful to be along on the team, but I do wonder, why did Eddie Lampert just take his claim and say, oh, everybody else go ahead in front of me?
Well, that's a great question. Because there's so much extra money, certain amounts of money that are kept, they're going to be taxed. Okay? So if he gives the money back, it's not taxed. It'll just go to us because we got to get paid anyway. So go ahead. You're on mute, Adrian.
Sorry. So is it like, I mean, he just lost that money? Is he just counting it like, oh, like, I just don't understand, like, from his side. I get that he wants to save on taxes, but does he get anything in return for it other than just saving? Okay.
Yes. Because it's intercompany, he wouldn't have had it anyway. We would have split it with him anyway. So he's technically not giving it back. It's so much extra that it just poured down to us.
Okay.
And he did it this way early. So he kind of leaked it. Oh, by the way, I don't need that claim. And by the way, if you look up document 2321, page 6 and page 12, he said he was going to do this. Document 2321, page 6 and 12, he said, put everybody in front of me. And that document is 3 years old. He said, I don't want nobody to think I'm ripping them off. Pay me last. And if there's any money extra, I'll let you guys get paid first. I'm that confident that it's going to be that much money left. So just you guys get in front of me, and I'll take the back of the line.
Is that sexy? That's hot. That's hot.
It's document 2321,
Nice.
page 6 and page 12. He said, put me in the back. I'm that confident that we're gonna get paid. Put me in the back. Y'all go ahead. Y'all go ahead and get paid.
I love it. Thanks, Steve.
No problem.
Wow. E, we got Charles. Charles, your hand is raised. Go ahead. Thank you, Adrian.
Hey, good evening, everybody, and thanks for having me on. How's everybody doing? How you doing, Mr. E?
All right, I'm good. I'm good.
All right, blessed to have you here. Just questions for you. One, When you mentioned that, I guess there was an announcement that saying we were 30 to 60 days away. What was that announcement? And what exactly was that announcement? I missed that part.
That's in the transcript on page 62 when they're explaining to the judge. And if you get the transcript, which Blair's going to send out to you guys, don't waste your time with the legal mumbo jumbo. You just need to look for effective date and time. So the effective date is when the assets go into the liquidating trust, and right after that, they can pay us out. So it's 30 to 60 days to the effective date, and the only thing they have to do is transfer everything over to the liquidating trust. Now, by the way, we cannot get paid until Transform is a public company or they merge with Lands End, Seritage, or AutoNation, because those are the three companies that Eddie Lampert has the most control and stock in. So I expect that to happen in the next 30 to 60 days. So Transform is going to file an IPO, or they're going to merge with Seritage Growth Properties, SRG, or Lands End, LE. And Lands End is very undervalued, but it's not as undervalued as the bonds. So it makes more sense to buy the bonds. So all of the assets of Transform are going to go into that liquidating trust. They are going to cancel the stock, and we're going to get paid out. But you will know that we have not been wiped out. So don't freak out like some people are going to do when they say the stock is canceling. Well, there's no more Sears Holdings. There's only going to be Transform. So they're going to have to cancel it and give us new stock and new cash. Don't freak out and sell like some of these fools are going to do, because they're going to think we're wiped out. I hope they think we're wiped out, because if we can still buy cash and bonds, we might get them for less than a penny on the dollar. There you go. Jason put the QSIP in the chat for the bonds. But I promise you, you won't see a chance to make 25 to 50 times your money when the money is already sitting there. You probably won't see too many opportunities like that. So you can buy the bonds as often as you can, as long as you can, until they're available. Okay, did I answer your question?
Yeah, you did. I had another question. I think you just answered the second question too, because I was going to ask, what would be the motivation for Wall Street to try to convince people to sell their shares, especially when you can't buy any more stocks right now that I'm aware of. I don't believe there's anywhere you can purchase any more stocks, just bonds. But for what you just said, it would be to bring the price of the bonds down so you could get even more bonds for cheaper, kind of like a
no, I'm sorry. Let me interrupt you. Let me tell you the motivation. Yep. I want to ask you a question. Have you ever seen this many people talking about a company supposed to be worthless online?
No, I haven't.
For this long.
So.
Okay.
No.
And people are angry online. Am I right or wrong? Do they seem happy? They seem angry, and nobody seems to think it's worth anything. Am I right or wrong?
Right.
Yeah,
okay.
Correct.
Yeah. They have rooms full of people who are being paid to keep the stock price down. If Sears Holdings goes from 5 cents to 20 cents, these short sellers are getting collateral calls. So without boring you with all the complications, when the stock price goes up, it costs them millions and millions and millions of dollars, just from 1 nickel to 20 cents. You familiar with what happened with GameStop, correct?
Absolutely.
Okay, so these people have shorted Sears Holdings, and they can't go buy the stock to return it. So they need the stock to stay at 1 cent or go to zero, because when we get paid more than $100 a share, they're going to be financially ruined. So they have to convince people to sell. And believe this or not, people who have directly talked to me for 4 years, people who have all my articles, my emails, they have been selling their stock over the last couple of weeks, and I have been shocked that they cannot wait. They don't need the money. They have been convinced by people online, people who called them on the phone, people who emailed them that they did not know. And I pray those people stay away from me, because if you are that crazy, I don't need you anywhere near me. So yes, they haven't. Anytime you see people talking about a penny stock and mad and angry, they are being paid to promote people selling the stock. They have to get the price down. And that's what's going on. Those are not people who own the stock. Why would you care if Sears Holdings were worth zero? Why would you be posting all day? Why would you be writing articles on a company worth 10, quote, 20 cents, according to, why would you care? 800 comments, 1,000 comments. Why would you care? Doesn't make any sense. They have a financial incentive to keep the stock price down. And I hope they keep it down so we can keep getting that in the bonds. So I hope they keep talking crazy. So anyway, I answer your question.
Charles?
Yes, sir. Yeah, you did. Yeah, if any of your friends want to sell any more of their shares, see if they can exchange it with me on E-Trade. I'll buy them.
Absolutely.
You and me
Hey.
both.
Hey, everybody, we got DC raising his hand. Thank you, Charles, for your comments. Go right ahead, DC.
Yo, what up, E? What up, everybody?
I'm good.
So, E, I had a couple questions pretty much revolving around the same topic. So I noticed that some of the bonds that I purchased not too long ago, they had been in the red forever. Then all of a sudden, over the last week or so, they went green. So I was wondering if you could explain what might have triggered that. And also, if you could explain just what triggers the stock price to move between 12 cents and 20 cents randomly throughout the week, because I didn't really understand how there was a market if you can't buy in the United States. And I'm like, what's causing the price to fluctuate? So I want to know if you could just elaborate on that a little bit.
Yeah. I've got clients overseas that are still buying. Clients overseas are still buying the stock. And people email me all the time. They direct message me and they say, hey, I'm in Germany. I can still buy the stock. I'm going to load up. And I say, God bless you. Do you think? I cannot tell you why the bond prices are fluctuating because I have no idea. But I hope they keep going down. I can't tell you. I can't tell you. I don't know if a big person's buying or selling, but I hope they keep going down.
Okay,
I tell you, it has nothing to do with the fundamentals. I'll tell you that for sure. It has nothing to do with the value. I'll tell you that with 100% certainty. And the challenging part, Danny, is not being able to go somewhere else online and find somebody that's talking about what's really going on. It's literally all negative. It's you're going to lose your money. It's all this crazy, but nobody is posting documents, facts, and everything I'm showing you. A lot of it is not even complicated legal stuff. So tomorrow the stock might be $1 or it might crash to a penny. So you have to make sure you're focused on what the court orders say and what the court transcripts say. You can't follow the Wall Street Journal, CNBC, because they're not going to deep dive on a company everybody thinks is, quote, bankrupt. And that's what makes our opportunity so great. I mean, I've never seen bonds. I've been in bankruptcy cases for 26 years. I've never seen bonds trade this low for this long after they've been guaranteed a payout. Usually somebody is following the case and they kind of figure it out. Sears is the first case I've ever seen where literally nobody who invests in distressed companies believes it's worth anything. And everybody's calling me, from Goldman Sachs, people from Merrill Lynch, people from all the major distressed debt, people who invest in bankruptcy companies as a specialty. They called me and said, hey, Sears Holdings is broke. I don't know what you're doing. They didn't even look at the paperwork. They were just so convinced there were no assets. And as I've shown over and over, the unencumbered assets have been there the whole time. All right, did I answer your question, Danny, DC?
Yes, sir. Appreciate it.
Okay, good to go.
Okay, if we can, hold on 1 second, Charles. We're going to hear from Jason, if you don't mind. Jason, right? Go ahead, then Charles. Go ahead, Jason.
Go ahead, Jason.
Hey, Eric. Thanks a lot for doing this. So I've read, and I think that I heard you say this before, but I'm a little bit confused. And I've also read it, I think, with maybe some of these reorganizations. But is there for some reason I've written down something about 40%, like the merged company or whatever has to have at least 40%. Do you know where that number came from and what that means?
Yeah, I do. So in a tax reorganization, the consideration paid to the shareholders has to be at least 40% stock in the company that bought us. So we have to get at least 40% of the stock in Transform, and the rest could be 60% cash. But the minimum is 40% stock. You got me? So it's 40% stock minimum.
Okay.
That's an IRS requirement. I forgot the technical name for that requirement, but we can't get all cash, but we can get all stock. But the minimum is 40% of transform in stock. So let's say it's worth $100 a share. We could get $40 in stock, $60 in cash. Or we can get $50 in stock, $50 in cash. But we can't get less than 40% of our consideration paid out of this liquidating trust. It has to be stock, at least 40%. That's where that comes from.
All right. Yeah. Thanks a lot. Yeah, that makes sense. Thank you.
Okay. By the way, this is Jason Loon.
I go by Lon. Yeah.
Lon. Okay. Got you. And you work over with Professor Thompson at the same university, correct?
Right. He's just right across the street. Yep.
Okay. All right. And what department are you in? I just want the crowd to know.
Oh, I'm in the finance department. Yeah. The business school at Penn State.
Okay. Got you. He's at Penn State with Professor Thompson. Just want everybody to know. Some real players on here, guys. Real players on here.
Yeah, I've met him. He's a really nice guy. I met him in the business school one time. He's doing a lot of work on the Bloomberg terminals and stuff. So I met him one time.
Okay, got it. Good to go. Good to go. All right. Thank you very much. Any more questions?